live from the drama-free true crime destination. No doubts, no delays, just the facts, the fire, and the finality that stands tall. This is the final word. And a pleasant Good Friday evening, everybody. Welcome to Bethea'S Byte Reloaded, the drama-free true crime destination. And this is the final word, our end-of-week moment to slow down, look back, and make sense of the stories that carried us here. I'm Ernest Bethea, the last outlaw. So good to have you aboard. And let's really get into this. No noise, no sensationalism, just clear, grounded look at everything that happened, why it matters, and why we take it into the weekend. Let's talk about it. We are going to start things off in a courtroom, actually, in West Union, Ohio. We're kicking things off with a verdict. Not a verdict, excuse me, but we're going to start things off with a sentencing. Now, Brian Moser was looking to have his verdict in the death of his girlfriend's child go one way. But with judges, they have a thing about them about doing things the way they see fit. So as I bring this next screen up, you're gonna join me inside this courtroom, and we are going to take care of this thing together.
Good afternoon, on record. In case 2025-0090, said matter is captioned in the Court of Common Pleas. It's in the Criminal Division of Adams County. The state of Ohio is the plaintiff. Brian Moser is the defendant. It's noted that the matter returns to the court docket on the 24th day of March of 2026 for purposes of sentencing. The state of Ohio created in the form of Mr. Tyler A. Cantrell, Assistant Prosecuting Attorney of Adams County, Ohio, Mr. Aaron Haslam, Prosecuting County, Ohio. Also present is Mr. C. Nicholas Ring, Mr. Ring counsel for the benefit of the defendant, as well as the defendant, Mr. Brian Moser. Sir, you're Brian Moser?
That's correct.
Mr. Moser, your date of birth, please.
May 16th, 2002.
Mr. Moser, as you're sitting here right now, sir, the influence of any alcohol, drugs, prescription medications, or any of that would cause you in any way to be confused about today's sentencing hearing or unable to assist Mr. Ring should he need your assistance? Very well. Previously settled with that, the court has provided the pre-sentence investigation summary report, both counsel of record. State, I'll start with you. Have you had an opportunity to review same, and if so, are there any additions or corrections?
We have reviewed it, Your Honor. We have no additions or corrections ready to proceed to sentencing.
Thank you. Mr. Ring, same inquiry.
It appears to be correct.
Thank you. State of Ohio, you wish to be heard?
Yes, Your Honor. In this matter, the parties have a stipulation. We would ask the court to follow that stipulation, and then that stipulation is as follows. In regards to count 4, that the defendant be sentenced to a term of 10 to 15 years in prison. That's to run consecutive to count 8 of 30 months, to run consecutive to count 10 for 30 months, for a total term of incarceration of 15 to 20 years incarceration.
Are there any of the victim's family that wishes to be heard?
I have talked to the father is here, Your Honor. He's just here for support and to see this through. He did not want to speak.
Very well, thank you. Mr. Ring?
Mr. Cantrell has stated the stipulation correctly.
Mr. Moser, under Criminal Rule 32, you're entitled to make a statement. You're not required to make a statement, but you're certainly entitled to. Is there any statement to make, sir? Go right ahead.
I just want to deeply apologize to the family. And I just want to know that it's going to traumatize me for the rest of my life. I would not know the good actions I'm going to see.
Thank you.
Yes,
The court notes that on March 24, 2026, the defendant's sentencing hearing was held Pursuant to Ohio Revised 29-29-19, President of Court Defense Counsel Mr. C. Nicholas Rain, Assistant Prosecuting Attorney Tyler E. Cantrell, as well as Prosecuting Attorney Aaron Haslam, as well as the defendant Brian Moser, with Mr. Moser being afforded all rights pursuant to Criminal Rule 32. The court has considered the record, the oral statements, and the victim impact statements, as well as the pre-sentence investigation report prepared. Further considering the principles and purposes of sentencing, Ohio Revised Code Section 29-29-11A, which sets forth that the court sentences an offender for a felony shall be guided by the overriding purposes of felony sentencing. The overriding purposes of felony sentencing is to protect the public from future crime by the offender and others, as well as to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden of governmental resources. To achieve those purposes, the sentencing court shall consider the need for incapacitating the offender, deterring the offender and others from future crime, rehabilitating the offender effectively, as well as making restitution to the victim of the offense the public will vote. Further, this court must and will balance the seriousness of recidivism 29-29-12 and notes that it would not sentence Mr. Moser or any other defendant before this court based upon the race, ethnicity, gender, or religion. The court does find that the defendant has been convicted pursuant to a voluntary plea guilty in count 4 to involuntary manslaughter in violation of Ohio Revised Code 2903.04A, that being the felony of the first degree, and amended count 8 to child endangering in violation of Ohio Revised Code 2919.22, that being a felony of the third degree, and in count 10, child endangering in violation of Ohio Revised Code 2919.22B3, that as well being a felony of the third degree, all of which subject to Provision A of 2929.14 of the Ohio Revised Code. The facts of the case, July 1st, 2025, the Adams County Sheriff's Department was dispatched to a child not breathing, 2-year-old female. Upon arrival, Sergeant Phillips asked the male standing at the door where the baby was at, that being Mr. Moser. He advised upstairs. They started up the steps. At that time, Sergeant Walters was carrying the 2-year-old down the steps. Sergeant Walters then laid the baby down to start chest support. As lab squads pulled up, Sergeant Walters then ran to the squad with the baby. There was also Deputy Grooms, who was also present. Who was also part of the interview process. The court found from the police report that after being Mirandized, that the Adams County Sheriff's Department and their respective agents that were on scene did a very thorough job of the inquiry of the parties at that time. The things that from that stand out is during the inquiry, Mr. Moser stated that he had put all the kids to bed around midnight. He then went into the room with his fiancée, and she was already asleep. He made comment that he thought it would be cute for all 3 of the children to be up on the top bunk, these being all minor children. The court notes also that upon inquiry, Mr. Moser advised, I did not hit her in the head, and the forehead I did not. I put that on everything. Then he states, I don't recall hitting them anywhere, but on their butts, hands, or their mouth. I did not close fist them. I don't do that. Inquiries made by Detective Cooley. Did you hit her anywhere? His response, no, I didn't. It was a little telling that they'd been hitting him before, but not last night. And then he states, I believe I'm the only one in the children's room. I was the one getting up that kept checking on them before we went to sleep. I went in there probably 3 times. When he was asked to explain the bruises on the children, he explained I disciplined them. I don't know how they got there. Mr. Moser gave a statement to officers preparing the pre-sentence investigation report. His statement was as follows. I was staying with my girlfriend at the time in Hawkins. I wasn't working at the time. I was in charge of watching 3 children while she was at work. On the night of July 1st, 2025, I used corporal punishment on all 3 children and the death of one of the children there. I had a rough childhood. My mother had difficulty with drugs. My father had difficulty with alcohol. And he felt that he was abused as a child. He knows that what he did was wrong, and he plans to seek mental health treatment while incarcerated. The criminal background, there is none. Family history: he was born on May 16, 2022 in Brown County, Ohio, to Joe Ray Dean Rolfe of Kentucky and Terry Michael Smith Jr. of Manchester. Mr. Mosier reported he currently resides in Manchester, has one biological sibling, with the defendant being the firstborn. He has one half-step or step sibling. His father has had interaction with law, his mother as well, for their uses of alcohol and or drugs. He was raised in Manchester, Ohio, mostly by his mother until his father took over, describing his childhood as unhappy with the history of being abused. With the belt, he reported being placed in foster care to the parents being deemed unfit at that time. He was placed with his grandmother until his parents got custody back. He was never married and states that currently he was not in a relationship. He has one biological child who is 2 years of age with the mother custody. He reported never having any involvement with the Child Protective Services. He does not own any child support. Stated he has 3 close friends that he has contact with daily for being in jail. 2 have been in trouble with the law or engaged in criminal activities. He stated he has one acquaintance that he has contact with every other month that has been in trouble with the law or engaged in criminal activity. He also states he's never been affiliated with a gang. He completed the 12th grade of education at Eastern Brown High School, Southern Hills CTC. Stated he was suspended or expelled from school for fighting. He does not have any additional educational certifications. There is no military history. He rates his own health subjectively as good, but he does have some different concerns. Mental health: he's previously received mental health services through Shawnee in 2021, but failed to complete that treatment. He was diagnosed with multiple mental health issues through Shawnee Mental Health in the year of 2021. He did state that he completed mental health services through the Rulon Center in 2024. Reported he's previously been hospitalized for various self-harm issues. His substance abuse history: he reported he first drank at the age of 15, would drink 12 beers a day, a fifth of whiskey, or mixed drinks. He reported he was marijuana daily from the age of 6 to the age of 23. Reported that he ate mushrooms 3 times at the age of 23. He previously completed substance abuse treatment through Rulon's Center 90-day program, and in February of 2024, he was at transitional housing through Reach for Tomorrow in May of 2024, but failed to complete the transitional housing. His employment history is a crew member at McDonald's in February of 2025, Captain D's in October of 2025, McDonald's in October of 2023, and Walmart as an associate in September of 2021. He reports having no monthly income or expenses. He does get support from his family, and which makes it difficult to meet all the financial demands. In regard to recidivism, whether he committed the incident of football community control, that does not apply. Whether he has a history of criminal convictions or juvenile delinquency adjudications, the court has noted he has no prior felony, criminal, or misdemeanor convictions. Whether he's responded favorably to sanctions previously imposed on adult or juvenile court because of his incarceration, he has not violated his bond. Whether he shows a pattern of drug and alcohol use related to the offense and doesn't acknowledge or refuses treatment, he does show a pattern of alcohol and drug use related to the offense, but he has not completed any of the treatment. Whether he shows any genuine remorse, the author of the report suggests that he does not. The court would join in that in regard to his interaction about these proceedings. He scored moderate of 16 on the high-risk assessment system, indicating a moderate risk of reoffending. The reality of this is that when a system of justice and the public at large becomes desensitized to the constant tragedies we are exposed to, both nationally and locally, where suffering starts to feel routine, dulling empathy, and any urgency for change. Yet, harm to an innocent child thankfully breaks through that numbness. It shocks people and the participants in the justice system hopefully back into feeling, because it represents pure vulnerability violated. The court at arraignment advised the defendant, based upon the returned indictments, that he was facing 63 years to life incarceration. The court recognizes the necessity for plea negotiations and rightfully would expect attention to detail in all cases, but especially cases of such gravity where a young child's life is abruptly and unjustifiably terminated. The court would be disingenuous to suggest that it did not suffer concern when during the change of plea amendments had to be made to correct oversights, albeit, and hopefully those changes as well will be shot. We must recognize that while our minor children only compose 1/3 of our population, they absolutely compose 100% of our future. The stipulated sentence, while the court understands and accepts that the stipulated sentence is suggested to this court will not be following that stipulated sentence. This is a child that under the stipulated sentence, she will be turning 18 years of age, 3 years of age in 3 days. So 38 days shy of her 3rd birthday, which would have occurred on May the 1st of 2026. Under this agreement, that child, if there would have been the possibility of life, would not have even been 18 years of age at the time of release from prison based upon the minimum sentence. Therefore, the court, in considering the factors of felony sentencing, finds that only maximum sentences would suffice in regard to any assimilation of fairness in this case. Therefore, after due consideration, the court finds that the defendant is not amenable to available community control sanctions. In fact, there's mandated sentences. It is therefore ordered that the defendant shall serve a stipulated indefinite mandatory, does not stipulate, will serve an indefinite mandatory prison term in count 4 of 11 years, 16 1/2 years. And a prison term in amended count 8 of 3 years, which shall be served consecutive to the term imposed in count 4 and a stipulated, again strike stipulated, and a prison term in count 10 of 3 years, which shall also be served consecutive to the terms imposed in counts 4 and 8. For a total sentence of indefinite, mandatory sentence, of 17 to 22 years. And we serve in the Ohio Department of Rehabilitation and Corrections. Because multiple prison terms are imposed on offenses, the court is requiring the offender to serve these prison terms consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and or to punish the offender, and that consecutive sentences are disproportionate to this offender's conduct, which caused the death of this 3-year-old child, as well as the danger he poses to the public. And the court also finds that at least 2 of the multiple offenses were committed in 1 or more courses of conduct, that being the continual abuse of these 3 innocent children, and the harm caused by 2 or more of the multiple offenses so committed is so great, so unusual, and unfathomable, that no single prison term for any of the offenses committed as part of the courses of conduct would adequately reflect the seriousness of the offender's conduct and the seriousness of the results, not only the physical results, the loss of life, but also the psychological results in the damage to these children by being abused by someone that they likely at one point in time trusted, but likely in the balance of their last few weeks of life, I doubt that they did trust based upon the constant, or what appears to be constant, harm to these children. You're notified, Mr. Moser, that it is rebuttably presumed that you will be released from service of the sentence on the expiration of the minimum prison term imposed as part of the sentence, or on your presumed early release date as defined in section 2967.271 of the whichever occurs earlier in time. You're also notified that the Department of Rehabilitation and Corrections may rebut that presumption described in Division B2C1 of this section if, at the hearing held under section 2967.271 of the revised code, the department may specify determinations regarding the offender's conduct while confined, the offender's rehabilitation, the offender's threat to society, the offender's restrictive housing, if any, while confined, and the offender's security classification. The court's also notifying you, Mr. Moser, that if, as described in Division B2C2 of of this section, the department at the hearing makes the specified determinations and rebuts the presumption. The department may maintain your incarceration after the expiration of that minimum term or after the presumptive early release date for the length of time that the department determines to be reasonable, subject to the limitations specified in section 2967.271 of the revised code, or further notifies you. May make the specified determinations and maintain your incarceration under the provisions described in divisions B2, C1, and 2 of this section more than one time, subject to the limitations specified in section 2967.271 of the revised code. Further, you're notified that if you have not been released expiration of the maximum prison term imposed as part of the sentence, then you must be released upon the expiration of that term. You're notified that the department will be supervised, that you will be supervised under section 2967.28 of the revised code after you leave prison, because you're being sentenced to a felony first degree. Transitional control program permitted 2967.26 and/or your placement or transfer into an intensive program prison under Ohio Revised Code 5120.032. Both are specifically reserved for denial or notification that the Ohio Department of Rehabilitation and Corrections desires consideration of you for either transitional control or for the intensive program prison. You're notified that post-release control in this case is mandatory. You have mandatory post-release control of up to 5 years, but no less than 2 years. You fully understand that? If you violate any post-release control sanction or any condition imposed by the parole board under Revised Code Section 2967.28, the parole board may impose more restrictive sections of prison term not to exceed 9 months for each violation, or a maximum cumulative prison term for all violations not to exceed 1/2 of the originally stated prison term as imposed. But if the violation of your post-release control is the commission of a new felony offense while under post-revision, then you may receive a prison term of the greater of 1 year or the time still remaining under your post-release control up to that maximum 5-year period, and that may be required to be served in addition to being consecutive to any other prison term imposed for the new felony offense that caused you to be a violation of your post-release control. You are ordered to serve as part of the sentence any term of post-release control imposed by the parole board, as well as any prison term violation of that post-release control. You're then ordered conveyed to the custody of the Ohio Department of Rehabilitation and Corrections by the Adams County Sheriff's Department. You will receive credit for all days previously confined or incarcerated. It appears that would be 263 days. I believe that was calculated through March the 20th, so it would be 267 days as of today's date of March 24th, 2026. And you will also receive credit for any future custody days while you await transportation to the appropriate state penal institution. Mr. Mosier, you're notified that you may be eligible to earn days of credit under the circumstances specifically defined in section 2967.193 of the Ohio Revised Code. You're also notified these days of credit are not automatically awarded, but they must be earned by you in a manner specifically outlined under section 2967.193. State, I believe the report that I received from the probation department suggests that there was no restitution because proudly the community paid for a few expenses. Is that correct?
That is correct.
Very well. The defendant is further ordered to pay a fine of $2,000. The defendant is further ordered to pay all costs of prosecution of this action for which execution is awarded, as well as any fees permitted pursuant to Ohio Revised Code Section 2929.18A4. The Department of Rehabilitation and Corrections is ordered to full funds in the appropriate fund of the defendant's account to pay these limited financial sanctions as imposed. Under Section 2947.23A1A, if you fail to pay these financial sanctions or this judgment, or fail to make timely payments towards that judgment under a payment schedule that's been approved by the court, then the court may order you to perform community service in an amount of not more than 40 hours per month until the judgment is paid full, or until the court is satisfied that you're in compliance with the approved payment schedule. Under section 2947.23A1B, if the court does order the defendant to perform community service in lieu of, in exchange for the non-payment of the financial sanctions, then the defendant will receive credit as specified hourly credit rate for every hour of community service performed. It will reduce the judgment. By that, if it finds the imposition of these financial sanctions, the defendant has the past, present, and future income ability to satisfy these financial sanctions. The defendant, at the time of arraignment, was 23 years of age. I believe he still remains 23 years of age, correct? The defendant will have a period of incarceration that he will be able to earn $17 to $22 a month while incarcerated. The court has calculated the fines that would be approximately $10 of that per month. And so therefore, the court finds that based on that income ability in state prison, as well as his prior employment history as crew leaders of various food and beverage, that he has the past, present, future, and income ability to satisfy these financial sanctions. There has been no bond posted for the court's consideration of return to the surety for compliance or forfeiture due to non-compliance. The defendant shall submit to DNA testing pursuant to Ohio Revised Code section 2901.07. Because the court has imposed the maximum sentences, and especially consecutive, that it is now a final appealable order, and it's a mandatory appealable order. So there will be a mandatory appeal that will be submitted to the 4th Appellate District Court of Appeals for further review. You must know, though, that if you cannot afford the cost to file that appeal, then you're entitled as a United States citizen to file that appeal free of charge. If you cannot find any documents that we possess that you have your appeal of this court's decisions, upon your request, the court will provide those documents to you once again free of charge. If you cannot afford the cost to hire an attorney to represent you effectively, as Mr. Green has done in this underlying matter, then upon your request, the court shall forthwith or right away appoint an attorney to represent you, but you will be required to pay a $25 in this council fee fund. I stress to you and I emphasize to you that these matters must be timely filed, the notice of appeal within 30 days of today's date. The court is on constructive notice that there is an automatic appeal because of the maximum sentences, but I would respectfully request, Mr. Ring, if you would, if you'll still please file a notice of appeal.
Yes, sir.
State anything additional or objections like that noted at this time?
No, Your Honor.
Mr. Ring?
No, sir.
Sir, as I believe this is your biological child, is there anything else you would like to state to bring the court's attention?
Yes. I'm sorry.
You're fine, Counselor. Mr. Moser, is there anything else you'd like to bring the court's attention? Very well. We're adjourned. Thank you.
And that, ladies and gentlemen, is Brian Moser getting exactly what he didn't ask for. As you just heard, an Ohio judge chose to go beyond the agreed upon sentence on this past Tuesday when he sent a man to prison for at least 17 years for killing a child. 23-year-old Brian Moser pleaded guilty to involuntary manslaughter and 2 counts of endangering children in an agreement with prosecutors that recommended he serve 15 to 20 years in prison. But Judge Brett M. Spencer opted to hand down a sentence that went beyond that, finding that the proposed punishment didn't go far enough. While our minor children compose only 1/3 of our population, he said, they compose 100% of our future. The court will not be following the stipulated sentence. Moser had initially faced 7 charges of endangering children, along with voluntary manslaughter and murder charges, in the death of his girlfriend's 2-year-old daughter. On July 1st, 2025, Adams County Sheriff's deputies were called to a home where they found Moser with the unconscious child, along with 2 other children. While Moser initially denied hitting the children, he later admitted he used corporal punishment on all three of the minors, killing one. Moser, who was unemployed at the time, would watch his girlfriend's children while she was at work. Spencer noted in his decision to depart from the stipulated sentence that he had agreed to, the proposed 15 to 20 years. The victim in the case would not even have been 18 when Moser would have been eligible for release from prison. Had Moser been found guilty as charged under the indictment at trial, he would have faced 63 years to life in prison. Spencer ultimately sentenced him to 17 to 22 and a half years in the custody of the Department of Corrections. While Moser had no criminal history, he described himself to investigators as having a troubled past and an unhappy childhood marked by abuse. Born Terry Smith III, Moser changed his name just days before the child's death. That's according to the report from WKRC in Ohio. Moser's new name matches that of a character on the television show Dexter, which follows a serial killer. Excuse me. So only thing I can say to that, ladies and gentlemen, is justice served. Especially when the judge can take a recommended 15 to 20 year sentence and go well beyond that. That's I say that's justice for everybody involved. Let's move onward to the next story on tonight's docket. Looking for leniency? Try again. All right. Next on our docket, Austin Drummond, accused of murdering 4, is seeking a change of venue for his murder trial. That's right. A defendant facing 4 murder charges is trying from a community that he judged. Maybe that community knows a little something that we already know. We're in Tiptonville, Tennessee with this story. Excuse me. The man accused of murdering 4 members of a family and abandoning an infant on a stranger's lawn has asked for his upcoming trial to be moved. Austin Drummond has pleaded not guilty to multiple charges, including first-degree murder and aggravated kidnapping, in the deaths of James Wilson, Adriana Williams, Braden Williams, and Courtney Rose. In a motion reviewed by Court TV, Drummond's attorney has asked that the trial be moved out of Lake County, Tennessee, citing the area's small population and the pervasive media coverage of the case. The shootings on July 29, 2025 sent shockwaves through the rural West Tennessee community where the victims lived and prompted a week-long search for a suspect. The victims were the parents, uncle, and grandmother of an infant that was later found abandoned at a random individual's front yard, approximately 40 miles from the site where the bodies were found. Drummond was arrested on August 5th, 2025, approximately 70 miles away in Jackson, Tennessee. Drummond's girlfriend was the sister of the infant's grandmother. Lake County is among the least populous counties in Tennessee, such that everybody knows everybody, Drummond's attorney wrote in the motion, which proposes the trial move to Shelby or Davidson counties. Prosecutors filed a document indicating that they have no opposition to moving the trial. If he's convicted, the 29-year-old Drummond faces potential death sentence for the killings. He has previously served prison time for robbing a convenience store and threatening jurors in a case. He was also previously charged with the attempted murder of a prison guard while in jail and was out on bond at the time of the alleged killings. So for Drummond, as we just heard, the he's allegedly killed 4 victims and abandoned a baby, which has generated sustained public attention. The defense's argument claimed the pre-trial publicity has saturated the local population, creating bias that would taint the jury pool. They may cite social media commentary, local reporting, and community sentiment as evidence. The prosecution's position is that normally the state typically argues that voir dire, the jury selection process, is sufficient to filter out bias and that moving the trial is unnecessary and burdensome. Not this time around. They're saying, okay, no problem. We have no problem moving this out of Tiptonville County. The legal standard is judges normally weigh whether publicity is so pervasive and prejudicial that it threatens the defendant's constitutional right to a fair trial. Change of venue motions are granted, but not routinely. So we'll just have to wait and see whether Drummond will get that. This is a procedural fight with real stakes because where this trial is held could shape everything from the jury attitudes to the emotional temperature of the court. So we just have to wait and see where this is going to go. Personally, I think they may end up moving it out of Tiptonville, Tennessee, simply because of all the attention that small town is getting. Next up, the fathers of children cases plead for the heartless monster to stay behind bars. Now, this is one article I haven't read, but if this is anything like I think it is, then I will stand by these dads. Let's get to this one. We're in Cleveland. Oh, we're in Cleveland, Ohio. An Ohio woman accused of killing her children and placing them inside suitcases at a message to her judge pleading for the woman to be kept behind bars. 28-year-old Aaliyah Henderson was indicted by a Cayuga County grand jury on 6 counts of aggravated murder, 4 counts of murder, 6 counts of kidnapping, 3 counts of child endangering, tampering with evidence, and 2 counts of gross abuse of a corpse in the deaths of her 2 daughters. Mm, mm, mm. Okay, hold up. Before I can even continue this article, I am going to dip into my captions real quick. And I am going to put up the old trigger warning, which is gonna come scrolling at the bottom of your screen at any moment. There you go. Now I can continue. Henderson appeared remotely at her arraignment on Thursday, sitting silently in an orange plastic chair. Her attorney entered a not guilty plea on her behalf. On March 2nd, a man walking his dog noticed a partially buried suitcase in Cleveland, and upon opening the bag, discovered what appeared to be a dead body. Police were called to the scene and discovered a second suitcase containing a second body nearby. The bodies were identified as 8-year-old Mila Chapman and 10-year-old Amore Wilson. Days later, police arrested Henderson and charged her with her daughter's murders. Cuyahoga County Prosecutor Michael O'Malley said in a statement when the bodies were found, "This tragic case has shocked not just our community, but the world. We will vigorously advocate for our victims, Amora and Mila. Excuse me. And our thoughts are with all who love them. We will hold this heartless monster to account for the torturous homicide of her children." Again, excuse me. The medical examiner determined the girl's deaths to be homicide, but the cause of death remains under investigation, prosecutors said. A victim's advocate spoke to the court at the hearing on behalf of the fathers of the victims. They have all expressed they would like the highest bond possible, as Ms. Henderson has a history of staying hidden and moving from place to place throughout the duration of the children's lives. A judge ordered Henderson to be held on $2 million bail and to have no contact with the 6-year-old surviving victim, identified only as NLH. Henderson is due back in court for a pretrial hearing on April 7th. Now, friends, I have absolutely no sympathy for I have no sympathy for Aliyah Henderson. None. Aliyah Henderson is a monster. Aliyah, I'll say it again and I'll keep repeating it until she goes to trial, she's found guilty, and gets every bit of jail time that she deserves. Aliyah Henderson is a monster because only a monster would take the lives of her own children. Only a monster will put herself in the position to where she will have no contact with the surviving 6-year-old. And let me remind you of this monster's charges: 6 counts of aggravated murder, 4 counts of murder, 6 counts of kidnapping, 3 counts of child endangering, tampering with evidence, and 2 counts of gross abuse of a corpse. Only a monster. Only a monster would put themselves at that position to be accused of something so dark, so sinister, so heinous. And to make it worse, you did it to your children. You're not a mother. You are indeed a monster, Aliyah Henderson. And I pray to God you get the justice you deserve. Let's see what we got next. And I do stand with the fathers making that plea to make sure that that heartless monster stays behind bars. Next on the docket, a judge is bewildered by a possible plea deal in a violent murder in Florida. The judge's response to this, it's news to me. Let me take off the trigger warning and I can go ahead and I can begin this next story. Yeah, I had to put the trigger warning on because of that story. It was so sick. All right, we're back. We're going to Tampa, Florida for this one. For the judge, it's news to him. A Florida man accused of killing his uncle with a car and leaving the scene revealed in court on Thursday that he intends to plead guilty, but not yet. No, let me run it back, but just in case you're watching this, you're saying, "What?" A Florida man accused of killing his uncle with a car and leaving the scene revealed in court on Thursday that he intends to plead guilty, but not yet. 24-year-old Jordan Aronson has pleaded not guilty to second-degree murder charges and was supposed to stand trial next week. But he abruptly changed his legal team this week. Aronson appeared in court briefly on Wednesday, where his attorney, Craig Weisenhunt, announced he was withdrawing, and a new attorney, Robert Malove, said he was joining the case. Weisenhunt, tongue-tied. Weisenhunt told Judge Gregory Green that Aronson had elected to hire private counsel and his authority was rescinded by the client. When Malove said he didn't even have the case file, Green ordered everyone to return to court on Thursday. Things were no less tense on Thursday when Malove informed the court that he was unavailable for the scheduled trial dates. The judge questioned Malove by saying, "Knowing you had a notice of unavailability, you took the case?" Malove said he took the case because he was informed Weisenhunt would be withdrawing, leaving Aronson unrepresented. In a motion reviewed by Court TV, Weisenhunt referenced an irreconcilable ethical conflict of interest as the reason for withdrawal. Despite asking for a continuance, Malove told the judge, this is not going to be going to trial. This is going to be resolved by way of a plea. And the judge responded, "Well, that's news to me." Prosecutor Melissa Grajales said in court that Aronson faces 20 years in prison if he's convicted as charged, but her office has extended a plea agreement to the defendant. Under the terms of the agreement, Aronson would plead guilty to a reduced charge of manslaughter for a sentence of 10 years in prison, followed by 5 years of probation. Malove said his client intends to accept the agreement unless he can secure a better offer. Ladies and gentlemen, this is another reason why I despise plea deals. But I'll withhold my commentary until the end. But I want to say for the record once again, in case you're just joining me for the first time, don't know who I am and where I stand on plea deals. I cannot stand them. The defendant allegedly admitted to investigators that he hit his uncle, Scott Grebler, with a car and left the scene, but maintained he did so after the victim hit him first. What? A witness reportedly told police he saw a black Jeep Wrangler reverse quickly out of a driveway with paper flying all over the road before speeding back into the driveway. The witness allegedly said the Jeep then reversed back at normal speed and idled for approximately 30 seconds. Then the witness heard two screams from the vehicle before it drove away. The witness then approached and found the victim face down on the ground next to the driveway, bleeding from his head and struggling to breathe, police said. In an interview with police, Aronson allegedly said Grabler threw a mug at his Jeep and chased him before punching him in the chest. He described trying to get away and said he hit his uncle with the vehicle while he was trying to leave. Aronson allegedly told investigators the fight began when his uncle accused him of stealing. But prosecutors say video evidence refutes Aronson's version of events. According to investigators, the video shows Grabler throw a binder at the Jeep, after which Aronson allegedly drives straight forward, hitting the victim with the driver's side of the car. As the victim began to fall to the driver's side of the vehicle, Aronson turned the vehicle towards that same side, appearing to track the falling victim, police said. Aronson is scheduled to return to court on July 13th, where he will be offered the opportunity to accept the plea agreement. If he declines, his trial is scheduled to start in August. Okay. He hits his uncle with a car. That, ladies and gentlemen, it's already grounds for vehicular homicide. But now he's saying he's willing to make a deal. He's willing to accept this particular plea deal unless something better comes along. And you wonder why I hate plea deals. This guy is literally playing let's make a deal with his life. And I guess to him, this would be the big deal of the day. If you want to use the version of the game show to follow this along, then let's do that. But here's what we know. Here's the way we know this. Behind door number one, he would stand trial and face 20 years in prison if he's convicted outright. Behind door number two, he'll accept a reduced charge of manslaughter and be sentenced to 10 years in prison, followed by 5 years of probation. And then there's door number three, this better offer that he's trying to secure. Are you kidding me? That's the way he's going to play this out? And the judge talking when he first found out that that the defendant is going to accept a plea deal unless he can secure a better one. No wonder the judge said this is news to him, because not only is it news to him, but it's confusing not only to the judge but to everybody else involved. Well, with the exception of the defense attorney, of course. Man. All right, let's move onward. We are going to go into the courtroom. A judge is calling the case against Kelsey Fitzsimmons exhausting as he delivers the verdict. Now, keep in mind, Kelsey Fitzsimmons decided on a bench trial, not a jury trial, a bench trial, which means the fact finder in this case is the judge. Let's see what we get here. All right. So, just like earlier, sent with the sentencing for Brian Moser, I'm gonna mute. I'm going to get out of the shot, and I am going to give to you the verdict against Kelsey Fitzsimmons.
Good afternoon. We're on record on the Kelsey Fitzsimmons matter, docket 2025, 77 CR 311. All counsel and the defendant are present.
Thank you. So, before I begin, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this. This is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And so, as the lawyers know, unlike when a judge presides over a jury waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply These prosecutors and attorneys fought hard, performed their solemn jobs fairly with the utmost civility and professionalism. They served as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and officers doing the best they could under tragic, rapidly evolving circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following 3 things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these 3 elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Outlaw, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Katie. It is not to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agreed that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamant and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a gun on Officer Noonan, and my verdict is, and must be, not guilty. With that, I will hand the signed verdict slip. I will hand the signed verdict slip to Mr. Wayne and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders it to be discharged of this indictment, and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing with intent that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you. Court is in recess. Good. All right.
Wow. When the evidence is there, it's there. When it's not, it's not. And the judge back that in his statement as he clears Kelsey Fitzsimmons of charges she assaulted one of her colleagues from following a bench trial and hours of deliberations. Kelsey Fitzsimmons was acquitted of assault with a dangerous weapon after an incident at her home on June 30th, 2025. At the time, Fitzsimmons was an officer with the North Andover Police Department. Her colleagues had been sent to her home to deliver a restraining order. The 29-year-old Fitzsimmons said she raised a gun to take her own life as things escalated. Instead, she was shot by fellow officer Patrick Noonan, who testified Fitzsimmons pointed the gun at herself, but not at herself, but directly at him. The case saw a swarm of publicity in the months before trial as Fitzsimmons was held in jail for more than 100 days after she was unable to blow into an alcohol detection device. I understand this case has generated a lot of passion and emotion, but you must remember this is a courtroom and not a sports arena, warned Judge Jeffrey Karp before delivering the verdict. Fitzsimmons had waived her right to a jury and placed her fate directly into Karp's hands. The judge said, "This has been one of the more exhausting, hardest things I've had to do as a judge. There is no requirement that a judge explain their reasons for reaching a verdict in a bench trial. I do in this case because I think Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30th, 2025, deserve an explanation. Karp said he found both Noonan and Fitzsimmons credible when they testified. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants doing the best they could under the tragic, rapidly evolving emotional circumstances. What I also saw was a young woman, Miss Fitzsimmons, who was also a dedicated public servant, reacting to sudden, confusing, and heartbreaking news. Karp said his deliberations focused solely on whether Fitzsimmons committed the assault, whether she meant to commit the assault, and whether she did so with a dangerous weapon. Issues such as the legality of the restraining order that sparked the incident, the reasonableness of the procedure used to serve it, and the custody issues surrounding Fitzsimmons' young son were pushed to the side. It is not my place to decide these issues or even mention my thoughts on them, Karp said. I am thankful for this because my role has been hard enough. Karp suggested that the decision would have been easier had any of the officers in question been wearing body-worn cameras, which were not a part of the department policy at the time. Under these circumstances, he said, I am left with reasonable doubt. And it is reasonable doubt that won the day. Kelsey Fitzsimmons not guilty in her cop on cop assault trial, and like I once said, even in an acquittal is still in some ways justice served. But I gotta give the judge his respect for the way he remarked about that. Okay, time to go back and hit the trigger warning again because I got a case coming up that is absolutely sickening. Okay, the trigger warning is up. We are going to go to my next article here. A police officer and her husband are accused of sexually abusing a teen foster child. Yes, a married couple entrusted with the authority with authority and care now stand accused of betraying both through the sexual abuse of a vulnerable foster teen. We're going to Plymouth, Massachusetts, where a Massachusetts police officer and her husband are facing a slew of charges after a child in their care allegedly told officers that they were sexually assaulted for years. 37-year-old Daniel Foran and 31-year-old Samantha Pellerine are charged with rape of a child and indecent assault and battery for alleged incidents dating back to 2018. Both appeared in court for a first appearance on Thursday afternoon and pleaded not guilty. Prosecutor James Duffy offered a summary of the allegations against the couple in court, saying that the two took in a 14-year-old foster child in 2018. In 2019, when the child was still 14 years of age, Duffy said that Foran began abusing the teen by performing oral sex on him and forcing the child to reciprocate. Foran and Pellerine got married in 2019. The alleged victim told officers that shortly thereafter, Pellerine walked into the master bedroom and found Foran abusing him. Pellerine allegedly turned around, left, and did not return for the rest of the day. In another incident, Duffy recounted in court, Pellerine allegedly told Foreign, I don't want to take his virginity. To which Foreign allegedly replied, he's already lost his virginity. Prosecutors described multiple alleged incidents that involved oral and vaginal sex with both defendants. The alleged victim told police that Foreign initiated and directed all the encounters until February 2020, at which point Pellerine began initiating encounters as well. Duffy said the abuse continued until 2025. Pellerine's attorney, Joseph Krosky Jr., flatly denied all the allegations and said the alleged victim in the case has a troubled past. Krosky said the child came to the couple's home because there was no place else for him to go. After the teen made allegations against his biological parents, he certainly came to the home with some documented problems, Krosky said. He was on medication and had several diagnoses. Krosky suggested the alleged victim had fabricated the story, saying that when he turned 18, the alleged victim requested Foreign and Pellerine adopt him. Krosky said that the problems started because the teenager began dating someone and wanted her to stay over, which Foreign and Pellerine would not allow. Oh, let me go ahead and give you guys a shot of one of our defendants on the left side of the screen in uniform. Pellerine works as a police officer with the Plymouth Police Department and was featured on the department's Facebook page for National Women's Month in March 2023. In that post, she said she always wanted to be a police officer. In a statement on Thursday, the Plymouth Police Department said it was appalled and deeply disturbed by the allegations and that Pellerine's duty status is under review. Pellerine was given a $10,000 bail and Foreign was given $25,000 bail. Both were ordered to surrender their passports and weapons, stay in the state, and have no contact with the alleged victim. The two are due back in court for a probable cause hearing on June 8th. Police officer and her husband arrested on charge after prosecutors say they sexually abused a teenage foster child in their home. Allegations surfaced after the teen disclosed the abuse, prompting a criminal investigation that quickly escalated to the officer's position of trust. The couple faced multiple felony charges. This case highlights vulnerabilities in the foster care placements, particularly when children are placed with individuals who hold institutional authority. And it raises questions about screening, oversight, and how abuse can occur even in homes that appear stable and credentialed. Now, something about this, aside from the obvious, just didn't make sense, and I'm going to, and to me, it goes back to the the attorney for one of the defendants, Joseph Krosky Jr. Okay, the victim had a troubled past. Okay, that doesn't mean the cop and her husband had any kind of right to abuse the child sexually. So okay, the child had no place else to go because the biological parents. Have you heard from the biological parents, or is that just something you that is something that just came up out of nowhere, out of left field? Or how about this? How about this? What medication was he on? What was he what was he diagnosed with? What stories is this teen fabricated? Did the alleged victim want to be adopted by foreign and Pelrine? There's a lot there, but it really doesn't make all that kind of sense if all that is true, but he's being sexually assaulted by this cop and her now husband. Make it make sense. All right. A couple days ago, we talked about Jarvis Butts being convicted and sentenced for the murder of Naziah Harris. Now, Jarvis Butts is dead, or at least he was found dead. Ladies and gentlemen, I can tell you, sometimes you can take your own life, guilt will get you. All right, here's what's going down. 2 weeks after he was sentenced for murdering a teenager and sexually abusing others, a Detroit man was found dead in prison. Jarvis Butts was sentenced to 35 to 65 years on March 12th after previously pleading guilty to, to the second-degree murder of Naziah Harris and criminal sexual contact with other victims. Prosecutors had said that Butts murdered the teenager after finding out she was pregnant with his child. Butts was silent at his sentencing hearing, which saw Naziah's grandmother break down in tears on the stand and two other women removed from the courtroom after shouts were heard. Justice will never be served, Naziah's aunt said at the sentencing hearing. You're still able to live. You're still able to get health care. You're still able to breathe without any remorse. While the Michigan Department of Corrections still shows Butts as being in custody at the Charles Edgeler Reception and Guidance Center, a representative for Michigan's Department of Corrections confirmed to Court TV that Butts was pronounced dead on March 26th, exactly 2 weeks after his sentencing. MDOC provided life-saving measures which were unsuccessful, the spokesperson said. The Michigan State Police have been called in to investigate the death, which is currently being considered a suicide. Maybe these words from Marquetta Harris, Naziah's aunt, is what triggered him. You're still able to live. You're still able to get health care. You're still able to breathe without any remorse. And on top of that, the very first word she said was, justice will never be served. Here's what happened. Jarvis Butts, who had just been sentenced to decades in prison for the murder of Naziah Harris and multiple sexual assault charges, was found dead in custody. Officials confirmed his death but have not yet released the cause. The discovery comes 2 weeks after his sentencing erupted into shouting, sobbing, and courtroom removals. He received 35 to 60 years for murder and 10 to 15 years for each sexual assault count, all concurrent. The hearing was volatile with emotional outbursts and multiple people escorted out. He was found, word is he was found unresponsive in his cell, Authorities have not confirmed whether foul play, suicide, or a medical issue is suspected. The investigation is underway, as is standard for any in custody death. His death effectively closes the criminal proceedings against him. For the victim's family, who never recovered Naziah's body, this development may complicate any remaining hopes for closure. And prosecutors have said Butts provided information about the body's location as part of his plea, but it's unclear whether that information is fully verified. This is an abrupt end of a case defined by violence, grief, and courtroom chaos. The justice system has reached its conclusion, and then the story took one more turn, raising new questions about accountability, safety, and what happens when a defendant dies before all answers are known. Like I said, sometimes guilt will gnaw at you and gnaw at you until you decide to do the unthinkable. I won't. I really can't say that he'll rest in peace because even I highly doubt that. All right. Before a verdict could be reached, a juror had refused to deliberate in Suzanne Miracle's trial. What was that about? Your guess is half as good as mine. Deliberations got off a rough start in Suzanne Miracle's murder trial when one of the jurors refused to participate in discussions. The 62-year-old Miracle is charged with murder, aggravated assault, and criminal damage in the death of her boyfriend, James David Barron. Miracle admits she shot Barron through the door of the bedroom in the home they shared, but maintains she acted in self-defense when she pulled the trigger. After 6 days of testimony, which included the defendant taking the stand, the jury was handed the case on Thursday afternoon. But within 2 hours of being sent back to begin deliberations, the jury sent a note to the court saying it had a problem. The note indicated that a single juror was refusing to participate in any discussions. The note read in part, quote, as declared immediately in the room, he will not change his mind, he will not discuss and deliberate. We have talked about how we want to understand his reasoning because we are collectively here to reach a verdict and help each other make a decision. He said he is not obligated to change his mind or to be open-minded. He was open-minded in the courtroom. Everyone is concerned and explained they are concerned. He entered with bias. End quote. Judge John Brakefield skipped reading a portion of the note which he felt would have indicated which way the juror was leaning before continuing. He will not explain any reasoning other than it's his feelings, and he knows how these things work. We have tried explaining we value his thoughts and why he thinks that way, and said he won't do that because our opinion is ours and his is his, and he will not try to change ours. End quote. The jury was brought back into the courtroom where Brakefield reread the jury instructions to the panel before sending it back to continue deliberations. There were no further messages from the jury before it left for the day. The jurors returned to continue their deliberations on Friday morning. While prosecutors have painted Miracle in a fit of rage when she shot the victim, her attorneys have argued, that the defendant is a victim of abuse at the hands of her boyfriend. Miracle testified to a number of violent incidents in the relationship which she had never previously revealed prior to trial. If she's convicted of the top charges of murder, Miracle will face a life sentence in prison. So here's what I'm gonna do. I'm gonna take you right to that verdict. Let's find out what happened to Suzanne Miracle. Get it set here. And okay, there we go. First, I can take off the trigger warning. If it'll let me. There we go. And while that happens, I'm going to go ahead and
I understand it's deeply impactful. This is a relatively long verdict form, and I will have the clerk read it aloud, showing it to the lawyers. Let's bring the jury back. Welcome back. Madam foreperson, members of the jury, everyone can be seated. Thank you so much. We appreciate your hard work on this matter. I'm not going to have you read the verdict. If you would you please hand the verdict to the chief bailiff? Representatives of the state and defense, please approach. Thank you. Madam Jury Clerk, please publish the verdict.
In the Superior Court of Hall County, State of Georgia versus Suzanne Renee Miracle, case number 2025 CR 516. As to count 1, we, the members of the jury, find the defendant Suzanne Renee Miracle not guilty. As to count 2, we, the members of the jury, find the defendant Suzanne Renee Miracle not guilty. As to count 3, we, the members of the jury, find the defendant Suzanne Renee Miracle guilty of felony murder during the commission of first-degree criminal damage to property. As to count 4, we, the juries of the members of the jury, find the defendant Suzanne Renee Miracle guilty of the lesser included charge of reckless conduct. As to count 5, we, the members of the jury, find the defendant Suzanne Renee Miracle guilty of first-degree criminal damage to property. As to count 6, we, the members of the jury, find the defendant Suzanne Renee Miracle not guilty. As to count 7, the jury find the defendant Suzanne Renee Miracle guilty of tampering with evidence. So decided this 20th of March 2026 by the foreperson.
Madam Foreperson, is that the jury's verdict?
Yes, Your Honor.
May this jury be excused.
Judge, I'd like to poll the jury, please, court.
Members of the moment, I'm going to ask some questions, and I apologize, I don't have your numbers memorized, but we're going to pass you a wireless microphone, and if you would identify your juror number and answer the questions, okay? Please hold. Defense, the 3 questions I'm going to ask each individual jurors. Is this your verdict? Was this your verdict in the deliberation? Is this your verdict now? Any objection for defense?
No, sir.
Any objection from the state?
No, Your Honor.
Madam Foreperson, and y'all can remain seated if you choose, if you wish to stand, that as well. Madam Foreperson, what's your juror number?
25.
Question 1, is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
State your juror number.
2.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror number, please.
18.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror number.
81.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
You? Juror number.
51.
51. Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror
4.
Number 4. Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Juror number.
89.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
65.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
94.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes. 10.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Do you have his number?
I apologize. Thank you. What's your number?
28.
Thank you.
20.
Is this your verdict?
Yes.
Was this your verdict in the deliberation room?
Yes.
Is this your verdict now?
Yes.
Thank you, members of the jury. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No, sir.
I'm going to excuse this jury with gratitude for your service. If you would, you're excused the deliberation room. I will speak with you briefly, not discussing the case, and we will allow you to depart. Thank you.
And that will do it for Suzanne Miracle. Georgia Dennis facing a life sentence after she was convicted of killing her boyfriend who was shot through a door. The 62-year-old faced a list of charges including malice murder, felony murder, aggravated assault, and criminal damage in the death of James David Barron, who was killed on March 7, 2025. After deliberating for several hours over 2 days, the jury delivered a verdict of not guilty of malice murder, but guilty of felony murder, also finding her guilty of the commission of first-degree criminal damage to property. Miracle is scheduled to face sentencing on May 11th. Miracle and Barron began a serious relationship in 2024, and in October of that year purchased a home together on Lake Lanier. But prosecutors said that by March, the relationship was having problems, specifically because Miracle had become aware that Barron was sending money to a woman from his past who lives in Moldova. Miracle's defense said it went beyond just sending money. Barron was allegedly bringing the woman and her daughter to the United States and was paying for a $3,500 a month apartment in New Jersey for them. In opening statements, prosecutor Jennifer Bagwell described Miracle as becoming unhinged and shooting the victim in a fit of rage after an argument. Investigators say when Barron retreated upstairs to the bedroom and locked the door, Miracle came after him and fired her Glock 9mm through the door. The bullet struck Barron, killing him. Bagwell said Miracle then got a hammer and used it to bang holes in the door until she could unlock it and get in. Once inside, Bagwell said in her opening statement that Miracle went into damage control mode. Rather than deliver any first aid to the victim, Miracle allegedly grabbed Barron's Beretta firearm and placed it in his hand, then fired 2 to 3 shots from the weapon. Bagwell also said Miracle admitted to police that she flushed several rounds down the toilet before officers arrived. Miracle's defense attorney, Brett Willis, told a very different story in his opening. He told the jury that while Miracle initially thought she was in a relationship with Prince Charming, the reality behind closed doors was very different. This was somebody who had opinions about what she wore, what she was to eat, what she was to do with money from the sale of her dental practice. This was someone who put their hands on her over and over and over again. Miracle's defense said that on the evening of March 7th, Barron had sexually assaulted the defendant before taking away her phone and the keys to the only functioning car before retreating to the bedroom. While her defense conceded that Miracle fired a shot through the door, they said she was trying to break the lock so she could get her phone. Responding to the allegations that Miracle tried to stage the scene with Barron's Beretta, Willis said that the 2 shots fired from the weapon were suicide attempts. Honestly, though, if they did all that, if it went all this route only for the jury to progress anyway and still find Suzanne Miracle guilty of on murder charges, then I've only got 2 words to that until the sentencing, and that's justice served. All right, next up, the biggest story of the night. There are reports going down that the alleged Long Island serial killer, Rex Heuermann, is expected to plead guilty to those murders. Oh, man. Did anybody see this coming? After years of mystery, fear, and speculation, the man accused of the Gilgo Beach serial killings is reportedly preparing to admit guilt, a seismic shift in one of America's most infamous cold cases. Let's break this down. We're in my birth state of New York, people. Accused serial killer Rex Heuermann is expected to change course and plead guilty to murder next month. That's according to sources close to the case have revealed to multiple outlets, including the Associated Press and NBC News. Shout out to both. The 62-year-old Heuermann was a Manhattan architect who lived on Long Island before his arrest as the prime suspect in the brutal murders of 7 women whose bodies were found buried on Gilgo Beach. The victims, all petite women in their 20s, were involved in the sex trade. Their remains were all found buried along an isolated stretch of shoreline not far from the home where Heuermann lived. Heuermann initially had pleaded not guilty and most recently was in court in September, where he lost his bid to have the murder charges separated into different trials. Now it appears there will be no trial at all. 2 people familiar with the case spoke with both the Associated Press and NBC News, saying that Heuermann now plans to change his plea to guilty at a court hearing scheduled for April 8th. Court TV reached out to Heuermann's attorney, Michael J. Brown, who said he was not commenting at this time. The remains of the victims on Gilgo Beach were first found in 1993 when hunters discovered the body of 28-year-old Sandra Costilla. In September 2000, the skeletal remains of 24-year-old Valerie Mack were found, months after her initial disappearance. 3 years later, Jessica Taylor's body was found. She was 20 years old. 2007 saw the discovery of Maureen Brainerd Barnes, who was 25, who was last seen leaving her hotel to meet a client. In 2010, the remains of 24-year-old Melissa Bartholomew were found. When Bartholomew disappeared in 2009, she told a friend she was leaving to meet a man, and her cell phone data last placed her on Long Island. 22-year-old Megan Waterman had traveled to Long Island from Maine for sex work. Her body was found on June 6, 2010. Months later, on September 2nd, 27-year-old Amber Costello was last seen leaving her home to meet with a client. Her body was found on December 13th, nearby the bodies of Brainerd Barnes and Waterman. Heuermann was arrested after investigators used advanced DNA techniques to link him to the killings, according to prosecutors. Heuermann's daughter Victoria said last year that she believed her father was guilty. Heuermann's ex-wife Asa Ellerup has repeatedly said she believes her ex-husband is innocent. Several other bodies of women also believed to be sex workers were found along Gilgo Beach, but no charges have been filed in their deaths. Now, Why plea now, though? Recent findings suggest prosecutors have amassed overwhelming digital, forensic, and cell site evidence. Defense attorneys may be seeking to avoid a lengthy, high-profile trial with potentially devastating testimony, and a plea could limit exposure to additional charges or harsher sentencing outcomes. Many of the victims' families have waited more than a decade for answers, and a guilty plea could bring resolution, but it could also reopen wounds tied to years of uncertainty and fear. This isn't just a procedural update, it's a turning point in a case that shaped national conversations about policing, cold case work, and the vulnerability of marginalized victims. And this guilty plea could rewrite the trajectory of the entire Gilgo Beach narrative. So we'll wait for the guilty plea come next month. Next up, an ex-New Jersey middle school teacher accused of sexually assaulting a student in the car and in the classroom. So sounds like another one of those cases. I'm gonna have to throw the trigger warning up. Seems like I'm throwing that trigger warning up like it's the bat signal. Here we go. Yeah, former New Jersey teacher has been arrested and charged after authorities said she sexually assaulted a student multiple times, both on school grounds and inside her vehicle. The allegations surfaced after the student disclosed the abuse, prompting a criminal investigation and the teacher's immediately removal from any educational role. Here's what 36-year-old Ashley A. Fisler is facing multiple charges, including sexual assault of a minor and endangering the welfare of a minor. Police allege Fisler and the minor had sexual encounters in Fisler's car and classroom in 2021. The alleged victim, now an adult, reported the incidents in January, according to police. Fisler denied the allegations in a statement to authorities. A former New Jersey middle school teacher is accused of sexually assaulting a student in her car and classroom. 36-year-old Ashley A. Fisler is facing 8 charges, including sexual assault of a minor, endangering the welfare of a minor, and official misconduct of a public servant, according to Gloucester County Police. According to the prosecutors, the alleged victim, now an adult, reported the incidents to the police on January 23rd of 2026. The alleged sexual encounters take place while Fisler was the student's teacher at Orchard Valley Middle School, as authorities have claimed in a press release. Fisler and the alleged victim had sexual encounters in her vehicle and classroom in 2021, according to the prosecutor's office. According to a probable cause affidavit obtained by People, the prosecutor's office conducted a forensic analysis of digital devices belonging to the student. Authorities claim they found numerous text messages between the victim and Ashley Fisler, which confirmed the existence of a sexual relationship between them. In addition, multiple nude photographs of Ashley Fisler were identified as having been sent to the victim, according to the affidavit. Also, Fisler, in a statement, denied the allegations made against her by the victim. Fisler has a first appearance in court hearings on March 27th, which was earlier today. The former teacher faces up to 20 years in state prison for each first-degree charge and 10 years for each second-degree charge, according to prosecutors. According to Fox 29, Fisler has not worked at the middle school since April of 2023. Well, if she did it, that is most definitely the moment that she gets to do her time in prison. All right. Now it is PSA time. And this one is coming from our friends with the crisis text line. And if I can get that bar up here, it'll be good. All right. While I'm waiting on that, I can go ahead and deliver this to you. If you or someone you know has been the victim of sexual abuse, again, you don't have to be a victim. You don't have to be a statistic. Help is just a phone call away, or in this case, a text away. You are asked to call strength. You are asked to text the word strength, STRENGTH, to the crisis text line at 741-741 to be connected to a certified crisis counselor. Your biggest weapon right now is this, and help is just one text away. The word is strength, STRENGTH, to the crisis text line at 741-741. Okay, now I've said my piece on the case. I have I'm going to take away the trigger warning. And let me see what I've got left on my docket before I go ahead and wrap things up. I may have something next. Yeah, I've got one last story. Police say that the death of a teen who vanished during a snowstorm and found in a creek is suspicious. A teen who disappeared in a snowstorm was later found dead in a creek, and investigators now say the circumstances just don't add up. Let's find out. Let's find out what's going on here. 14-year-old McKenna Wendell was last seen in Sioux Falls, South Dakota between late evening March 13th and early morning March 14th. She was found dead in a South Dakota creek after being reported missing days earlier. Authorities believe her death is suspicious and are investigating her movements across multiple states before her body was found. McKenna is being remembered as a bright teen with a love for animals and the outdoors. Here's the article. Authorities investigating the death of a missing 14-year-old found in a creek earlier this month say her death was suspicious. 14-year-old McKenna Wendell was last seen alive in Sioux Falls, South Dakota between late evening March 13th and early morning March 14th. That's according to a press briefing from Sioux Falls police. She was reported missing on March 15th. Following a days-long search, her body was found on March 19th in Brookings, South Dakota, found in a drainage creek, according to the landowner of the property where the creek is located, according to USA Today. While authorities are awaiting a ruling on the cause and manner of her death, a Sioux Falls police captains said at the Monday, March 23rd press briefing that their investigation led them to believe that McKenna died under suspicious circumstances. The captain further said that authorities retrieved evidence indicating McKenna and others may have traveled to other locations within Iowa, Minnesota, and South Dakota. McKenna had been transported in a vehicle to the location where her body was found, according to the official, without specifying if she was alive or dead at the time. He told reporters that they were led to McKenna's body with the help of a citizen and someone with knowledge of the situation, but did not elaborate further. The captain further said a family member who has been arrested on unrelated charges of DUI is not connected to the case at this time, and that McKenna's family has been cooperative with investigators. This is McKenna when she was playing volleyball. McKenna, a beloved 8th grader, is being remembered as a bright, curious teen who loved animals, according to a report from USA Today. At her school, she kept a cricket habitat in her locker, and she had taken care of 2 hermit crabs before burying them in her backyard. She would beg to bring in any frogs found in the grass following a rain, according to her family. My clearest memories are the way she was able to make the people around her feel special and feel seen, her teacher Bridget Burgers said at her funeral. From a young age, it was apparent McKenna had a vibrant personality and a zest for life. She loved being outdoors, climbing trees, playing in the park, and riding her bike, read a part of her obituary. A verified GoFundMe has been set up by her family to assist with funeral costs. A second unverified fundraiser has also been set up, and GoFundMe says they're working to ensure funds raised through that account are directed to the family. The case is now under a multi-agency investigation spanning different jurisdictions, including Brookings County, South Dakota, Iowa, and Minnesota. Police are working with the FBI and U.S. Attorney's Office on the case. The investigation continues, and Sioux City police have urged anyone with information to reach out for them. Now, I can just say this and treat this like this is still a missing persons case. Whatever information you have, please don't hesitate with it. Get in contact with the Sioux City Police Department, and you can just give the information you can. McKenna may be gone already, but maybe your information can help save someone else. And as always, I say this all the time, and I won't put the bar up, but I'll still say it anyway. When it comes to missing persons, if you see something, please say something. That way, we can do something. All right, I'm going to go ahead and wrap this up for this Friday night, now into Saturday morning. This is Systems Push to the Breaking Point. This week reminded us, excuse me, this week reminded us, excuse me, good grief. Still trying to clear this cough. Let me try this again. This week reminded us that the justice system doesn't move in straight lines. It lurches, it strains, it gets tested by chaos. From courtrooms on the brink to cases that twist without warning. But even in the noise, there's a steadiness worth holding on to. The truth still matters. Accountability still matters. and the work continues, whether the path is smooth or jagged. So we close this week not with certainty, but with clarity, knowing that whatever comes next, we'll meet it with the same resolve to cut through the confusion and stand firm in the facts. That's the final word for this week, a clear look back at the stories that carried us through the week and the lessons we take with us. I'm Ernest Bethea, the Last Outlaw. Thank you for joining me. Stay safe, stay grounded, and stay informed. I'll be doing this with you again real soon. Until then, this is the drama-free true crime destination. This is Bethea'S Byte. And it's reloaded. You have a good night, everybody. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.